Hi, good evening to you all. So welcome back to the business law lesson, and today the topic is to discuss about the vitiation factors. What do you mean by the vitiation factors? So under the law of contract we say vitiation factors in a contract are those the factors existence of which will cripple or invalidate the contract. So it's clear through these vitiation factors a contract will be invalidated, or let's say they make the contracts voidable. So there are 5 types of vitiation factors we can see, as the first one is misrepresentation, second one is unconscionable conduct, third misleading or deceptive conduct, fourth is duress or undue influence, as well as the fifth one is the capacity of the minors. So we'll try to get an idea about these things. So the first one is a misrepresentation, as I told you earlier. So what do you mean by a misrepresentation? Now, as you can see in the presentation, it's sort of a cunning type, right? You can see a cunning face there down in the presentation. Yeah, what do you mean by a misrepresentation? So it's sort of, misrepresenting somebody, right? You represent something wrongly. That is the idea of misrepresentation. So it's an untrue or misleading statement of facts made during the negotiations by one party to another. Often these things are happening from the seller to the buyer. Now, as an example, we'll come into a sort of a case study later. But of course, when it comes to the party who buys a product, is always concerned as a ignorant buyer who doesn't have sufficient knowledge about the particular product, right? So in that case, the buyer become innocent because of he doesn't know about anything on the product, right? So in that case, if the seller tries to make sort of a misleading or untrue statement about the particular product, so that can be counted as a misrepresentation by the seller, right? So then the second point is then the statement inducing not majorly but sufficient to have even a less impact that other party to enter into the contract. Now, misrepresentation is just not a mere sort of a presentation of facts, but if it's really influencing the other party to make their decision or come into the contract, so that is a sort of a valid misrepresentation, right? So there are basically 3 types of misrepresentations where those can be happen. Now, when it comes to the innocent misrepresentation, it's sort of, we are not going to touch that particular part in this lesson, right? Innocent misrepresentation is something like, people are doing some sort of misrepresentations because of they being the innocent, right? So that is the idea of innocent misrepresentation. We are not going to discuss about the innocent misrepresentation here. So anyway, we consider 2 types of misrepresentations often happening in the business contracts. And of course, since we discussed about the misrepresentations of the negligence or negligence misstatements in our previous cases, we are not going to touch them here as well. And we are just focusing on the fraudulent misrepresentation, which is known as a sort of a tort, right? So we'll move. What do you mean by a fraudulent misrepresentation? Simply, a civil tort arising out of the contract law, and it is a false statement. Remember, it's a false statement of fact that causes or induces. As I told you, that should be inducing some person to come into a contract, right? So a fact that causes or induces someone to enter into a contract, right? The bad part is the party who has been fraudulently deceived can, there's a person. Now let's say, as an example, let's say the part A and part B, right? So the party A is the person who tries to sell something to the part B. So the party B, being the innocent, doesn't know about the facts, or without notice of any fact about the product. If the B buys a product from A under the influence of some sort of a fraudulent misrepresentation made by A, so that is counted as a fraudulent misrepresentation, and the B has the power to claim over the damages, right? As an example, when it comes to the second point, we can see the party who has been fraudulently deceived can sue for the damages, right? But it has to be fraudulently deceived, right? right? So we'll see the elements of the fraudulent misrepresentation, right? So misrepresentation to become a fraudulent one, you can see there are 4 elements to be satisfied. So what are they? Now the first one is, did the defendant make any representation of false fact? So the party, or let's say probably the seller, has to make any sort of a representation over the information that he reveals to the party, the party called buyer, on the false grounds. Let's say the false facts, right? And also the second part is, did the representation induce the plaintiff, the person who complains over this, right, or the person who deceived through the fraudulent act, was acted in a way of, in some way. Did it make any sense to the act of the influenced party, right? And did the defendant act dishonestly or recklessly, right? It can be dishonest, it can be reckless. And the fourth one is, did the plaintiff suffer losses or any damages as a result of false representation by the defendant or probably the seller, right? I used 2 words known as defendant and plaintiff, that is to express the party that they are denoting. So when it comes to that, you can say like basically these things are happening in between the transactions between the buyers and sellers. So in the case of false misrepresentation, basically the false are being made by the sellers, not by the buyers, right? So buyers are the people, those who are buying the products from the sellers. So in the case of sale, some of the sellers are making fraudulent conducts. So that is why I'm always getting the seller as the defendant and the buyer as the plaintiff, because once after they got to know there was a fraudulent act, so the necessary actions, or let's say the demanding, or let's say the claim over the damages will be happening from the part of buyer, right? So the buyer should be the plaintiff then, right? Moving to the next slide, we can see an example, right? So see the example. A buys a car from B, a car sale owner. Now B is the car sale owner and A is the buyer. So in this circumstance, you can see A searches for a car which is reconditioned one with a low mileage. See the criteria that he's searching for: low mileage and accident free, right? There are 2 criteria. One is low mileage, the other one is accident free, right? So 2 decision making variables, right? So he is an ignorant buyer because he doesn't know anything, right? So the seller has to reveal all the necessary information. It's not a must, but whatever the things asked by the A, B is liable to reveal all these things, right? But when it comes to these 2, definitely we have a presumption, or we assume that A would ask some of the questions related to the low mileage to reveal the mileage features, to get to know about the mileage and the accident status of this car. So we assume that, right? Because these are the 2 decision variables. So that is one. So when it comes to B's case, B promotes the car with actual low mileage. That one is fine, right? Actual low mileage, and presenting the false grounds on the status of accidents, right? So probably the car is met with an accident, right? So here the actual scenario is the car is a recovered one from an accident. So probably that may have damage to the car a lot, but here the B, the sale owner, the car sale owner, doesn't reveal any sort of a fact on the accident grounds and say, mentioning that the car is accident free, right? So in that case, he is ignoring, or he is unrevealing something fraudulently. That is the false grounds, right? This was met with an accident, so he knows, right? The seller knows about it, but actually he's actually hiding some of the information which can influence the decision of the buyer. So buyer see, now low mileage is of course correct, low mileage is there, and the car is accident free. Since of these 2 variables are fine with him, so definitely the buyer will go for the purchasing decision. In that case, A, being the ignorant buyer, because A is always like ignorant, right? He doesn't have sufficient information. buys it as a result of false representation. What was the false representation? The accident-free car. It was not accident-free, right? So in that case, as a result of this false representation, the buyer will buy the car, right? In that case, what has happened? Which was fraudulently with an intention of speculation. With an speculation purpose, the seller did not reveal on any accident grounds on that particular car, and as a result of that, this one has already bought it, right? So this is how the fraudulent conducts are happening. Then when it comes to the facts that we discussed about, the 4 facts that we discussed during our presentation, we'll consider the effect of all these things over the act. Right. So what's the representation? A false statement of fact. Yeah. So what is the representation? What was the representation? Right. Now see, the first point is statement of fact or merely an opinion. Statement of fact or merely an opinion. Now actually, if it's a statement of fact, that can be proven either true or false, right? But if seller gives an opinion in a way of opinion, it's just an expression, right? And it cannot be proven, right? So be careful with all these things. If it's a fact, of course you have the grounds of proving that. But of course, if it's an opinion, you cannot prove it because it's just an expression of a person, right? Now, as an example, let's say when it comes to the car seller in the previous case, now since he expressed it in a way of fact, this was like mentioning that the car is accident free, of course this is a fact, right? This can be proven because he revealed me this car was not met with an accident. So when it comes to that end, let's say if seller implied that he's in a he's recommending this car to buy because it's a good car, right? It's a sort of an opinion, right? It's not a directly expressed a sort of a statement. So because of that, you cannot prove, right? Then the second fact is statement of fact or merely a puff. Now in law, we have a sort of things called puff. What do you mean by a puff? It's a statement which cannot give rise to legal consequence. So it's like sort of, it can be influenced through legal consequences, right? So in that case, if it's merely a puff, you cannot make any actions against the fraudulent misrepresentation, right? Actually, in some circumstances, we see in some circumstances there are some sellers, those who are not revealing the facts and being silent, they try to hide some of the facts related to that particular grounds. As an example, let's say when this A and B incident, right? B was asking from A on the grounds of accidents. A was asking the grounds of accidents. If the B kept silence, in that case, it's not a fact to be presumed that since the car is accident free, the B person or the seller kept silence. No, that is not the fact, right? So silence as a statement of fact, we have to think it doubtfully, or let's say it's sort of the false grounds can be happening through being kept on silence, right? Then the next one is, was the representation false, right? So if it's a false representation of some fact, then definitely it's a sort of a fraudulent conduct, right? We'll go with the next thing. So did the representation induce the plaintiff to act in some way? Now if it didn't influence over, so you can't see any sort of influential or any sort of encouragement to the ignorant buyer, or let's say the innocent party, to act in some specific way, right? So you must aware about these things. Why? See, now the first point is influence the innocent party to act in some specific way, to make that particular buying decision. B's false statement had already made a grounds to encourage the buyer, or let's say the A, to buy the car, right? So it made an influence, because by not revealing the actual accidental grounds over the car, has made and has given an influence over the A's decision to buy the car, right? So it has already been influenced, right? Then the second one is influence the innocent party to rely on the representation. Now anyway, he made his decision solely by relying on the particular representation that was false, right? So innocent party to rely on the representation, there was an influence, right? And the third one is representation just sufficient and doesn't require to be the main inducement, right? It can be a part of, or even it can be a sort of a less material fact. But of course, if the representation or the fraudulent representation is in some way, if it is being an inducement, definitely it will be counted as an inducement, and it doesn't require to be the main fact or the main encouragement, right? The next one is representative doesn't require to inquire whether the fact is true. When it comes to the ignorant buyer, he is not going to check with your auction sheets and things like that. Basically he will get your auction sheet, but after that he won't, when it comes to the reconditioned cars, the people, those who are purchasing the reconditioned cars, are not going to the Japan sales auction, or let's say whatever the sales auction, and call them and ask whether these informations are correct. No, they are not going to ask them. So because of that, representative doesn't require to inquire whether the fact is true. So he is having the authority, or he is having the availability, or let's say he can accept whatever the seller tells to him, right, as the true representation of facts, right? And see, also to become a misrepresentation, a fraud, there should be more than the negligence. Plus, defendant must induce the plaintiff through dishonesty and recklessly, right? So to become a misrepresentation, it's not mere sort of a negligence, and there should be more than that, right? Rather a negligence, it should be a fact that someone has induced another through the dishonesty and being reckless, right? The next fact is, did the misrepresentation made a loss to the plaintiff? Yes, of course. Why? Now, the plaintiff, to claim the damage, must construct a causal connection between the fraud and the loss. Now, to claim over some sort of a damage which has occurred through this misrepresentation, the party deceived the damage should make a sort of a, construct sort of a causal connection between the fraudulent conduct and the loss, right? Without that, he cannot claim over the damages or sue over the damages, right? The next point is, once the causal connection is established, the defendant cannot rely on the disclaimer, ignoring the liability. Now, when it comes to that, once the causal connection is made, defendant cannot say no, and he cannot say any disclaiming parts saying that ignoring the liability of that particular incident, right? Because if there's a relationship, in the sense, if there's a connection between these two facts, the fraudulent act and the loss, definitely that is a fraudulent conduct. So once the connection is established, the defendant cannot say no to the act, or he cannot withdraw from the scenario where, without making any sort of a loss or damage claim to the whatever the compensation to the party affected, right? Then the second one is, then now here we discussed about the misrepresentations, right? Basically the fraudulent misrepresentation, right? And there were another two known as the negligent misstatement, misrepresentation, as well as the innocent misrepresentations. So we were not considered in our lesson. Now in this case, the second part is the unconscionable conduct. What do you mean by unconscionable conduct? Basically it's an unjust or unfair conduct, right? Now as an example, let's say if one party tries to make an advantage through getting a sort of a disability of the other party as a benefit or as an advantage or as a whole, let's say it's a mere opportunity, right? To make an opportunity, or let's say just by looking at the other party, if you see a sort of a disability of the other, let's say if a person doesn't have sufficient knowledge to come into the contract, and because of that you are asked to construct a contract, right? Then you make contract between that party and another, right? By making that an advantage of including some of the terminologies, or let's say the terms and conditions in that particular agreement or contract, which are very favorable to the other party, not the party who asks you to construct the contract, right? The party who's on the other side, and getting a commission through that. It's a fraudulent act, right? It's a sort of an unconscionable conduct, right? In that case, see, the one party or one person takes the advantage of another person's special disability, right? See the third one, an unconscionable conduct occurs where the one of the parties to the transactions were specially vulnerable. So you make somebody, or let's say make one party. Now let's say you are the part A, and the person who asks you to prepare the contract is part B, and the third party is part C. Now you being fraudulent or you being unconscionable, you making an unconscionable conduct to the B, you try to get an advantage from C to you, right? By adding some of unfavorable, or let's say some of vulnerable contractual obligations to B, right? Which is very favorable to C. In that case, you are totally unconscionable, right? So you make the party B to a vulnerable situation, or you are letting him or her to face for damages or losses or make in danger, right? So an other party took unfair advantage, so you take the advantage of that vulnerability. So in that case, you are vulnerable and you are unconscionable, right? So we'll move. So there are so many remedies that we can see in the, according to the act in the Australian law. We can see there are two provisions made, right? These things are happening from business to the consumers as well as in the markets of business to business. Those are known as B2C markets and B2B markets, right? In that case, we can see unconscionable business to consumer transactions and unconscionable businesses to the business transactions are the provisions made by the specific definitions, identified areas of Australian law. So there are remedies to be taken over these sort of unconscionable conducts, so known as the damages, right? The deceived party can claim over the damages, and also can be claimed over the injunctions, and ask for the compensation and other orders, right, which are very sufficient with the grounds of occurrences, and adverse publicity order, right? Especially these things are happening from business to business, where the businesses are trying to in some sort of advertisement scenarios, you can see these adverse publicity orders, and order disqualifying a person from managing a company, right? Especially when there's a, let's say if a person has made a sort of a complaint over or let's say if a person has sued over a person like a CEO, so definitely it's an order disqualifying a person from managing a company, right? An order requiring a business to establish a compliance, right? So that is why some of the companies are making some of standards and maintaining them, right? Without allowing their company to be in the case of unconscionable conduct. So that is why they are having prepared compliance schedules and all these things. And there's a remedy, right? Order requiring a business to establish a compliance, right? So without any compliance, if they are operationalized, so then the courts can ask them to make some sort of operational procedures and establish some sort of compliances, right? And also the pecuniary penalties, right? So the penalties are like the court can ask for sort of let's say the corporation penalties, right? Under a maximum limit, right, amounting to a maximum limit of penalty, right? So these are the remedies that you can take under the unconscionable conduct, right? So then the next one is misleading or deceptive conduct. So what do you mean by misleading, right? Make sure all these concepts are very similar but are having so many sort of small types of variations and differences between them, right? So distinguish the concepts in a particular manner. So where we discussed up to now, we discussed about two things. The first one was misrepresentation. The second one was unconscionable conduct, and this is the third one, misleading or deceptive conduct, right? So false representation of facts and influence the act of the innocent party. It's similar like the aforementioned both. False representation of facts and influence the act of innocent party. So also there you can see, as an example, if you say like you being a candidate for an interview, so you include some of the misleading information, like let's say if you are an undergraduate of a particular program, you say that I've been already completed my bachelor's degree in management, right? It's questionable, right? Because you didn't complete your examinations yet, so because of that you can't say like that. It's a sort of a misleading, right? So through that you are trying to get some sort of a benefit by the false representation. So that is one way of misleading, right? When it comes to the contracts, you say this land has basically when it comes to the agreements like the land sales, right? You say let's say this was owned by let's call somebody who is having very it's a known personality in the country, right? So it's happening because of the false grounds, right? It's sort of a misleading, it's sort of false representation of facts, right? Through that you try to not to bargain with the contractual party, and you try to earn something more out of that, right? Getting that sort of a goodwill to that particular land, right? So the next one is actually the remedies for the misleading or the deceptive conduct. So there are three types of known as damages, injunction, and order cancelling or varying terms, right? So you can cancel either you can cancel the order, or else you can ask the contractual party to vary the terms, right? Fine. Then let's go for the duress and undue influence. Now basically in some circumstances we can see mostly these things are happening in the commercial deals, right? Some party will induce you, right, through making some sort of unlawful threat to you. As an example, let's say if you are not signing the contract, so I will definitely I will definitely make your CEO to resign from his job, and I will recruit him, right? That's a one way of challenging, right? It's a sort of a it's an unlawful threat, right? It doesn't require to be kidnapping somebody and keeping that person with them, no, but somebody can ask you in that way, right? A commercial base, right? As an example, let's say you have a with your competitive priorities anyway. Let's say As an example, your CEO is there, that is your competitive priority. Let's say just because of his knowledge only your company is sustaining well. So in that case, if somebody can afford your CEO with a higher position and a higher salary, so then definitely he will resign from his job and go, right? So one party can say, I will make whatever the necessary arrangements to make your CEO resign and come and join with my company, while I'm putting you to a loss, right? You better you sign this contract and do agree with me, so then I won't do anything, right? So that is one way of making some contracts and conditions, right? Fine. So what do you mean by duress and undue influence? Inducing a party, mostly the innocent party, to enter into a contract or to bound by the contract on unlawful threat, right? Which is unlawful. Unlawful threat can be in the means of physical, mental, or economical damage or harm, right? At present, we can see most of the regulatory bodies are made some sort of regulations over this economical duress, property duress, and things like that, right? And to make it as a duress or undue influence, there should be three conditions. See, serious, illegitimate physical injury, property damage, or economic harm. Party has to be induced to enter into a contract only due to a threat, right? And since there are no alternatives available, so the party has made that particular contract, right? There are three conditions to make a duress or undue influence contract through the duress or undue influence, and the parties can, the innocent party can actually sue over a sort of a case by basically making that claim over all these three conditions, right? Should be a physical injury, property damage, or economic harm, and the party has been induced through entering into a contract through an unlawful threat, or since there are no alternatives available, so the contractual parties had made that particular bond between them, right? So contracts formed through the duress are voidable contracts, as it was in the misrepresentation, unlawful or duress or undue influence. Those whatever the contracts are made through duress, undue influence, so illegal or unlawful threat are known as voidable contracts, right? Because the party's assent or the party's consent is very much needed to make it an agreement, right? So since the one party is agreed but the other party is agreed based on that particular unlawful threat, right? So because of that we can't say both the parties are having the assent over making that sort of an agreement, so which become voidable, right? So the capacity of minors, the last point, right? What do you mean by capacity of minors, and who are the minors? Minors are the people those who are below the legal age, we call it as a legal age of 18 years, right? So when it comes to the Australian context, we can see the people those who not exceed 18 years are not entitled to bind by the contracts, because those are concerned as minors. That is actually for except New South Wales, right? And a contract with a minor for sale of good is not enforceable unless the goods sold are necessaries, right? Let's say the goods sold are necessaries. Unless the goods sold are necessaries, a contract with the minor of the sales of the goods is not enforceable by the law, right? And if a contract with a minor is not for necessaries, it is generally voidable, right? It's clear now, right? Now when it comes to this, I told you that condition was with not with the New South Wales, but when it comes to the New South Wales, the situation is totally different, where the New South Wales, where the Minors Act in 1970 presumes that all the contracts for the benefits of the minor, be careful, right? All the contracts for the benefit of the minor are binding, provided the minor does not lack the necessary understanding because of his or her youth, right? They don't care. Presume that all the contracts for the benefit of the minor are binding, provided the minor does not lack the necessary understanding because of the his or her youth, right? So in New South Wales, it is considered as lawful to have a even to have a contract with minors, because the youth, being youth, or that his or her youth doesn't affect over the necessary understanding about this, the legality, or let's say the the importance of and the severity of the contractual relationship. So because of that, you can say like that. Right, so these are the things that I've intended to do today. So thank you very much for listening to my lecture, and if you do have any concerns, let me know. And thank you very much for being attending to the lecture.